Thanks for joining us today for another mini webinar about FDA regulation of tobacco products. Hasn't been long since you last saw us, but the FDA has been busy and so have we. Briefly, we are the Public Health Law Center located in St. Paul, Minnesota, and we have been the go-to resource for public health law and policy for nearly 20 years. We provide legal technical assistance, which includes resources and publications, policy drafting, and webinars like this one. All of the work that we do is done in consideration of advancing equity. What that means is that we are focused on partnering with communities and organizations to use the power of law and policy in a way that addresses the social determinants of health and meets the specific needs of all communities, especially those who unfairly bear a greater portion of public health and other societal harms. Here's the agenda for today. Desmond and I will be tag teaming this webinar on the FDA's guidance that was issued last week. We're going to give you some background information so that the guidance will make sense. Then we'll walk through what the guidance does and we'll highlight the gaps in the guidance before talking about the process going forward. And we'll hopefully have time for a few questions at the end. So to start us off, Desmond will share some background information.
Before we dig into the guidance, we have to talk about pre-market review, which is what the guidance is about. In the broadest terms, FDA pre-market review of tobacco products resembles drug review in that it prevents the introduction of a new tobacco product without first receiving authorization from the FDA. The Tobacco Control Act has a cutoff date for what is considered a new product, February 15th, 2007. Now, no e-cigarettes that are on the market today were available on that cutoff date. If they were, they'd be exempt from pre-market review entirely, and they could stay on the market until the FDA took some other action. So that means that all of the e-cigarettes that are out there technically require authorization before they can be sold. We'll circle back here in a second. You should also know that the Tobacco Control Act only gave the FDA immediate authority over cigarettes, smokeless tobacco, and roll your own tobacco, and cigarette tobacco. The law says that for any other product made or derived from tobacco and intended for human consumption, the agency must deem the product to be subject to its authority. This has some important implications for pre-market review. First, you can only submit a marketing application to the FDA if the agency regulates your product. And until the FDA deemed e-cigarettes, it didn't have regulatory authority. So the agency couldn't even accept an application for an e-cigarette until the deeming rule was final. Hopefully you've already noticed the catch-22 here. A manufacturer can't sell its products until the FDA has regulatory authority and has affirmatively authorized the marketing. So according to the letter of the law, on the day that the FDA begins its regulation of e-cigarettes, the agency would have to remove every single e-cigarette from the market and then review applications before only allowing those products that meet the statutory standards back on the market. This is a big logistical problem for the FDA, but like all enforcement agencies, the FDA has enforcement discretion. If you get lost in the background information, I just want to flag a couple of resources for you. You can find these on our website in the FDA Tobacco Action Center. The first is this fact sheet, which will run through some of the material we're about to cover. If enforcement discretion is a confusing concept, you can go back and watch our last 30-minute webinar, which digs a little deeper. For now, let's talk about the implementation of pre-market review after the deeming rule. So to solve the FDA's day one catch-22 logistical problem, the agency decided to phase in pre-market review rather than try to crack down on e-cigarettes and other newly deemed products immediately. There's a few different sets of deadlines, but we're going to focus on the deadlines for e-cigarettes. This is what the FDA came up with for the final deeming rule. E-cigarettes are allowed to stay on the market without filing an application with the FDA until the rule has been in effect for 2 years. So that would have been August 8th, 2018. We put a big red box on this chart so you can see where we're at currently on this timeline. Those applications would have been due at the end of last summer. There's a decent chance that we would have seen some products exit the market at that point. Manufacturers that decided to submit applications could keep their products on the market for another year until this coming August. But at that point, the FDA was going to begin removing products from the market that didn't have marketing orders. The possibility of removal was a major incentive to get applications in as early as possible. It's also worth mentioning here that this version of pre-market review was challenged by the e-cigarette industry and upheld in the courts. This is a perfectly legal way to implement pre-market review. The FDA announced a major change in tobacco regulation in July of 2017. I'm overlaying that date with the effective date of the deeming regulation with my favorite e-cigarette sales slide. If you missed our previous mini webinar on the FDA's Juul Enforcement Blitz, we look at this information a little closer. That recording is also on our website. In July 2017, the FDA announced that it would start working on nicotine reduction and take another look at flavors. What didn't make as big of news at the time was the change to pre-market review, and it was just as significant and had a much more immediate impact, partially because it was implemented just weeks later. Now, before we look at that timeline from the 2017 regulatory plan, it's worth showing you this. We haven't talked about the litigation challenges to the deeming rule much lately, but not long after the FDA announced its 2017 regulatory plan, a few cases were dropped or stayed because, in the words of the industry, the 2017 plan afforded them much of the relief they were seeking, and that relief was the drastic change to pre-market review. This is the 2017 regulatory plan timeline that replaces the timeline in the 2016 deeming rule. There are two very important changes. First, and probably the most obvious, the deadline for applications has been pushed out incredibly far into the future, August 8th, 2022. We're still 3.5 years away from that date. The second one might be less obvious. You'll notice that the previous timeline moved swiftly to white. In that area, the only products on the market in the white period are products that have gone through FDA review. The 2017 plan's timeline does not have a white area, and that's because under the 2017 plan, so long as manufacturers submit an application, the product is allowed to stay on the market indefinitely. If you analyze that important difference between these two timelines, you can understand that the FDA has shifted the incentive on when to file an application. Again, the original timeline incentivizes getting an application in as soon as possible, perhaps even before the deadline, because there might be a point where the agency would remove a product from the market if it hadn't received marketing authorization. The 2017 plan's timeline actually incentivizes the latest possible submission. Because manufacturers have no fear of having their product removed before they've submitted an application, they will likely submit their application at the absolute last moment. If they submit early, they might get a denial from the FDA. If they submit as late as possible and still get a denial, they will have been able to keep selling their products in the interim. The way to maximize profits is to submit an application as late as possible so your product can stay on the market for as long as possible. The industry is aware of this because, according to Commissioner Gottlieb, no e-cigarette company has filed a marketing application as of yesterday. So, as we have said many times before, this reworking of pre-market review is incredibly problematic and inevitably jeopardizes public health in a completely unnecessary way. That's why several public health groups filed a lawsuit and challenged this change to pre-market review. That case is still pending, but hopefully the courts will force the FDA to adjust its 2017 timeline. Now, after the FDA pushed back the dates of pre-market review, Juul sales skyrocketed. Now, we're not saying that the FDA caused Juul to take off. Juul's marketing to youth, its high nicotine content, and usage of nicotine salts are a toxic mix that has led to this epidemic. However, it is clear that the drastic change to pre-market review was beneficial to Juul and other manufacturers, and was definitely a contributing factor to the e-cigarette epidemic. That's why pre-market review is the tool that the FDA is using to attempt to take a comprehensive action.
We have been urging the FDA to revisit its approach to pre-market review and to stringently enforce the provisions that would have a more comprehensive and immediate impact on the e-cigarette epidemic. Additionally, the FDA has frequently made announcements of its intentions to plan to take action. At the same time, the FDA's hope that the industry would take voluntary action to address the epidemic is naively optimistic and out of touch with how the industry actually operates. These announcements have not created any tangible results, and even worse, they give local, tribal, and state authorities false hope that dampens momentum. That being said, the FDA's draft guidance is the first step the FDA has taken towards genuine action that would begin to address the youth e-cigarette epidemic. First, I want to give you an overview of how the FDA is treating categories of products based on the product's characteristics. This includes e-cigarettes and cigars. The first category the FDA announced it would prioritize is e-cigarettes that are not flavored with tobacco, mint, or menthol, if those products are offered for sale in kid-accessible ways. That includes products sold in locations where youth can enter at any time, which applies to any portion of a store being accessible to youth, meaning retailers cannot just make an adult-only section within their existing store. This also includes products that are sold to minors in an undercover buy inspection. Any products that are sold online, those that don't limit the quantity a purchaser can buy within a certain time period, and those that do not use enhanced age verification techniques. For example, requiring a driver's license number, which is then used to verify the age with a third-party service. The same group of e-cigarettes, those that are flavored with something other than tobacco, mint, or menthol, will also have a change in the deadline they are required to file their pre-market review application. What this means is that if you sell these products and you limit your sales to adult-only stores, you limit the quantity a purchaser can buy online, and you use enhanced age verification for online sales, you have until August 8, 2021 to file your pre-market review application. If you fail to do any of those things, you would likely have to file your application much sooner. For all other e-cigarettes, those that are tobacco, mint, and menthol flavored, and this would also include those that are unflavored, the deadline remains August 8, 2022. Also in the guidance is the prioritization of enforcement for all e-cigarettes, regardless of flavoring, that market, advertise, or label in a way that is targeted towards or especially enticing to youth. Previously, the FDA has sent warning letters to certain companies that indicate the FDA's thinking on what could raise these concerns. To make this point, there is no exemption for mint, menthol, or tobacco-flavored products. So if those products use these advertising and marketing techniques, they are also subject to the FDA's prioritization of enforcement. The last category of products the FDA addresses in this guidance are flavored cigars. The only flavor this would not include is a tobacco flavor. We know that flavored little cigars are an obvious progression product either for youth attempting to satisfy their nicotine addiction or when flavored e-cigarettes are not as easily available. These products are not distinguishable from cigarettes in any meaningful way, but unlike cigarettes, come in an array of flavors in small pack sizes and are generally cheaper. It is a demonstration of foresight by the FDA to simultaneously address these products. This guidance states that the FDA intends to prioritize enforcement against any flavored cigar that was on the market at the time of deeming and cannot be considered a grandfathered product, meaning any flavored cigar introduced into the market between February 15, 2007, the grandfather date, and August 8, 2016, the date deeming was effective. Previously, the deadline for pre-market review application for any cigar was August 8, 2021. Now that date only applies to tobacco-flavored cigars. All other cigars will be subject to the prioritized enforcement process. For all other products, the 2017 regulatory plan deadlines for pre-market review remain in place. One last caveat about the announcement is that the FDA intends to prioritize enforcement against any products that enter the market post-deeming. Many in the public health community have brought these illegally marketed products to the attention of the FDA. If these products had a marketing order, that would be public information. The FDA has not taken any public action to remove these products from the market, even though they are clearly illegally marketed, and some of these products remain on the market to this day. In this guidance, the FDA states that it will also prioritize enforcement against any newly deemed product that enters the market or has entered the market post-deeming without a marketing order. Now that I've explained the difference depending on the categories of products, I want to try to explain what the process could look like. If you are unsure after reading this guidance document exactly what the FDA intends to do, you would not be alone. We had a similar reaction. Even though we know which sorts of products and sales methods the FDA is attempting to crack down on, the guidance is unclear on what happens if a manufacturer steps over the line. This is unclear because of the language the FDA is using to describe its activities. You'll notice that the guidance repeats the phrase, intend to prioritize enforcement. By enforcement, they clearly mean the enforcement of pre-market review, but there are many ways for the agency to enforce pre-market review. The most stringent enforcement would be for the FDA to require a product to be removed from the market entirely, and the product could only return to the market after the FDA authorizes it. Prioritizing enforcement in this context could also simply mean that the FDA will review the applications for the offending products First, after they are submitted in the 2021 or 2022 timeline. However, that would really not be much of a deterrent to the sales practices that the FDA has identified. The agency could also have something else in mind because there are almost an infinite number of ways that enforcement could be prioritized. It's also worth noting that we don't know how the FDA will prioritize among all the products and policies that is said it is prioritizing in the guidance itself. The point being, there are a lot of ambiguities, which hopefully the comment and finalization process will clarify. The FDA's materials note that the agency expects things to happen. That is, because the FDA has announced its intention to enforce pre-market review in some way, the agency expects the industry to start complying. But we're still left wondering what happens to those who don't comply. Hopefully, what we'll see is a swift removal of products from the market.
As you probably realized, there are a lot of gaps in this guidance, and some of them are pretty significant. It's important to consider them as you're drafting comments to the FDA. We're going to walk through the ones that we've noticed and think are really important, but obviously members of the public health community should weigh in on anything that they think is important. These gaps are the ones that can be fixed by amending the guidance and don't require rulemaking or any additional action. First, mint and menthol flavored e-cigarettes are given the same treatment as tobacco flavored e-cigarettes. There's no question that flavors are a major reason that youth experiment with these products, and we're glad to see FDA action on most flavors, but there's no reason to exempt menthol or mint. Importantly, Juul comes in both of these flavors, and we know that Juul is largely driving the current epidemic. Unfortunately, we don't have time to talk about the difference between mint and menthol today. We also know that more than half of high school e-cigarette users report using mint or menthol flavors. The marketing of these flavors has also been targeted at many groups, including African Americans and the LGBTQ community. Not including mint and menthol e-cigarettes will likely perpetuate tobacco-caused health disparities. Under the proposed guidance, these flavors would still be allowed in stores where youth can enter and online without quantity restrictions or the FDA's proposed heightened age and identity verification. They would, of course, still be subject to some age verification. And remember, the application deadline for these flavors is still 2022. There's absolutely no good reason to not move that date closer to the present by at least 2 years, if not more. The FDA has full discretion to move the due date for applications. We're not even talking about a deadline for removing the products. This is just the submission of the marketing application. And we do think that the FDA needs to implement a new deadline for the removal of products that don't have authorization. That is the only way the agency can really incentivize the submission of full, complete applications within a reasonable time. Online sales of e-cigarettes is another huge gap. The FDA did propose to ensure that non-mint, menthol, and tobacco-flavored e-cigarettes have better age verification, which is good. But there's no reason that the agency couldn't simply tell manufacturers to stop allowing online sales entirely. It's important to note that no one really knows how many e-cigarettes are sold online. All of the information out there is based on estimates. There's no Nielsen data for online sales or any other comprehensive data set. We do know that youth are consistently able to buy products online with little trouble. Certainly Juul and Juul-like products should no longer be available on the internet, given how easily youth have accessed these products in the past. Again, there's no good reason to include this kind of exemption. Let's also talk about application deadlines. Again, while the FDA moved up the deadline for non-mint, menthol, and tobacco flavored e-cigarettes, it didn't move it very far. We're still talking about a date that's 2.5 years away, and the agency didn't move the deadline for mint, menthol, and tobacco flavors. E-cigarette manufacturers have been on notice about pre-market review for several years at this point. It's time to require them to submit applications so that the FDA can finally evaluate them. And the agency needs to commit to taking products off of the market in order to shift the incentive back to filing applications as soon as possible. Cigar regulation is another area with some significant gaps. We're glad to see that the FDA did not exempt any flavors of cigars in this guidance, but there's still room to do more. Tobacco-flavored cigars are still going to be allowed in stores all over the country, and online sales will continue without restrictions that have been proposed for flavored e-cigarettes. And here as well, application deadlines are still extremely far into the future. There's nothing to stop the FDA from removing all cigars from stores that youth can enter, prohibiting online sales, and moving up deadlines. Finally, let's talk about water pipe and pipe tobacco. The FDA has not proposed to make any changes with respect to water pipe and pipe tobacco. That means all flavors will remain in all stores and online without heightened age verification. For water pipe, the FDA notes that there are questions related to how the product might be used in the absence of flavors. So if you have answers, put them in your comment. The FDA also notes that the cumbersome nature of the products make them difficult to use on school grounds. And while true, doesn't seem like a great reason to put off pre-market review for several more years for a product that is just as harmful as other combustible products, and we know is primarily used by people in their 20s.
In addition to the gaps in the guidance itself that could be addressed in the final guidance, there are also gaps that are likely to diminish the impact of any final guidance because those gaps must be closed through rulemaking. Research demonstrates that an alarming number of youth are transitioning between e-cigarettes to more harmful products, like combustible flavored products. This transition exists in the current regulatory climate with little restrictions on youth access to flavored e-cigarettes. Assuming the implementation of a final guidance reduces youth access to flavored e-cigarettes, other combustible flavored products will remain on the market. Those would be flavored cigars that were grandfathered, meaning they existed on the market on February 15, 2007, the grandfather date of the Tobacco Control Act, and menthol cigarettes that were exempted from the language in the Tobacco Control Act. The potential unintended consequence of driving youth to these products should be another important reason for the FDA to not delay 1 day longer on proposing a rule prohibiting flavors in all tobacco products, including menthol. The first public step in this process, the FDA sending a rule to OMB, has not yet happened, and the FDA's delay on this action is putting thousands of youth lives at risk. This is in addition to the African American lives that will be lost every day that the FDA delays on a prohibition on menthol, and has always been a pressing reason for the FDA to take immediate action to remove menthol from cigarettes.
Let's talk about the process for this guidance for a moment, because I bet a lot of people on the webinar are less familiar with this process versus the rulemaking process. The draft came out last week, and the FDA is accepting comments until April 15th. Clearly, the agency intended to move faster than normal on this guidance because it normally suggests that people get comments in within 60 days for best consideration. Guidance dockets don't actually close, so you can continue to submit comments after April 15th, but the FDA isn't guaranteed to read them before it starts working on the final guidance. As always, if you're looking for information, our website has it, and you can contact me or Natalie for help with comments as well. After April 15th, the FDA will start reading comments and finalizing the guidance. We don't know when the final guidance will come out because just like rulemaking, there's no deadline. The agency has said that the guidance will become effective 30 days after the final guidance is issued. So even if the FDA acts really fast, we're probably not going to have an implemented guidance until June or July of this year at the very earliest.
While our discussion of the guidance has taken up much of our time in this webinar, I want to emphasize that our final point is not a small takeaway and is perhaps the most important message from this webinar. This action cannot and should not stymie work to address harmful tobacco use and the e-cigarette epidemic at the tribal, state, and local levels. As we have said before, while this is one step in the direction of genuine action from the FDA, the details are murky and the timeline is indefinite. Community-driven action remains our most important line of defense to try to curb youth commercial tobacco use. Nothing the FDA is proposing is getting these products off the market anytime soon. What that means for communities is do not wait a single moment to continue the fight against an industry endangering the lives of our youth.
All right, I think we have time for a question or two. First, when is the earliest the FDA could actually remove any tobacco products from the market? That's a really good question, and the typical lawyer answer is it depends. Obviously, it's going to depend on how soon the guidance is implemented. Um, like I mentioned a minute ago, the earliest possible timeline reasonably could be, June, July, August, probably, where the guidance is out and final for 30 days and implemented. At that point, the FDA is doing retail inspections all the time. They're aware of what products are in stores. So if manufacturers, don't take any action to remove their products from stores, and the FDA finds those products right away, and they intend to enforce the law in a way that means they're removing products immediately, then it reasonably could be the end of this summer, maybe early fall. I don't think that's probably likely. I think the FDA is going to get a lot of comments to this guidance document, and they're going to have to read them all. And if they make pretty significant adjustments, they might have to give, or they might decide to give the industry more time than 30 days. And then again, it also is going to depend, as Natalie mentioned, on exactly how they enforce pre-market review. If when they find a product that violates one of their priorities for enforcement, they give the manufacturer a certain amount of time to file an application, and the product gets to stay on the market, then we could be talking about, years maybe rather than months. It really does depend. But it seems like the FDA is finally moving in the right direction.
Last fall, the next question is, last fall, Commissioner Gottlieb announced that the FDA would ban menthol in cigarettes and cigars. Why would the FDA treat menthol and e-cigarettes differently in this guidance document? What the FDA is saying in the guidance document is that they are treating them differently because they are still trying to leave e-cigarettes available for adult smokers to transition to less harmful products. And they think that mint and menthol e-cigarettes are essential in that transition. But we know that these are also enticing flavors for youth, that they are using these in high numbers as well. Not quite as high as other flavors, but high enough that it doesn't warrant any exemption for menthol flavored e-cigarettes.
Yeah, and the other thing is cigarettes, the FDA doesn't really have the same policy lever with respect to cigarettes because because the FDA had regulatory authority over cigarettes at the time of the Tobacco Control Act. There's actually a separate window in time where manufacturers could put in applications and keep products on the market as well. So, and there were also, grandfathered cigarettes as well. So the pre-market review lever with respect to e-cigarettes and cigars is much more powerful. The FDA has more authority to capture all the products without any exemptions.
So that meaning that they would need to use formal rulemaking to address menthol and cigarettes and grandfathered cigars. And so while that is a long process in and of itself, what the point I was making on the webinar is that they haven't even taken the first step. They issued an advance notice of proposed rulemaking, which was a completely unnecessary regulatory step that could have even delayed their action to some extent. But the next step is to propose a rule, and that first step, the first public step is that rule going to the Office of Management and Budget, OMB, for approval. And so we would know if they have proposed the rule, and they have not.
And then we have time for one final question. And it is, how can the pre-market review process remove flavored cigars if the applications are for substantial equivalence with grandfathered flavored cigars? I assume that means with grandfathered flavored cigars as a predicate product. So anything that's grandfathered is exempt from pre-market review. So that means if there were flavored cigars on the market on February 15, 2007, those can stay on the market indefinitely. But if you're marketing a new cigar and you're using the SE process, that's one of 3 different pre-market review application processes that the FDA uses, but you're comparing your new product with the predicate product. So in this case, if you do have a predicate cigar and you have applied through the SE process, it actually doesn't matter which application process you're using, because the new product came to the market after February 15th, 2007. So because the products are still new and require authorization prior to marketing, the FDA can similarly pull the products off the market entirely and use this policy lever. But as Natalie mentioned, also, in order to get at grandfathered cigars, the FDA would have to do a rulemaking. Only a rule that prohibits flavors or some other action that would remove grandfathered products from the market is going to make sure that there are no flavored products whatsoever. Anything to add on that one?
No, that's comprehensive.
Okay. All right. We're going to stop there. We appreciate everyone tuning in and listening to us. And again, if people have questions or comments, or they want help with drafting their comments or anything like that, feel free to reach out and contact us. Thank you and have a good day.
Thanks.